Koutou mai, ko kiri ana huki ngā mahi o te kaunihera arohe o te matawa Māori. Uri atu ki a koe e te tuahine, e te whanaunga hine wai, tēnā koe. Tēnā koe. Uri rauna hoki ngā whanaunga o te rā pito o tātou. Ngāti hine manu, ngāti ngai tū pokoiri, ngāti hāwea, ngai te whatui āpiti. Tēnei te mihi atu kia koutou e Liz. Piri, koutou ma. Hoki mai rā kia koutou o te kaunihera. Ngā apiha, ngā rangatira. Tēnā koutou, tēnā tātou katoa. Thank you for the welcome this morning, Rex. I just thinking about if I cough, it's a cough that I've had for a couple of years. So when I cough, I don't want you to leave the room. When I was thinking about the presentation, so much is said about treaty partnerships. So I thought I'd spend some time on talking about treaty partnerships and spending some time about the treaty and its recognition and the rocky pathway that it had to get legislative recognition along the way. So we know that the Treaty of Waitangi is commonly referred to as our founding document. And sure, it was signed in 1840. But we need to remember that it was signed at a time when Māori outnumbered Pākehā by 50-1. And that Māori were militarily more powerful even at a tribal level. And that Māori were secure in their resources. Those for me are little important points that we need to hold on to. But the road to recognition for the treaty was anything but smooth. For instance, in 1877, Chief Justice Prendergast, in the case the Wiparata versus the Bishop of Wellington, declared the treaty a legal nullity. Ngāti Toa of Porirua had gifted some land to the Anglican Church, in return for which a church and a school would be built. No church or school was built, and the Anglican Church attempted to sell the land. Ngāti Toa argued the case on the basis of their treaty rights. The land had been gifted and not used for its intended purpose. And under Article 2, Ngāti Toa had retained their rangatiratanga over the land. Chief Justice Prendergast threw the treaty rights argument out by saying, you cannot argue on the basis of treaty rights, because to have treaty rights, you have to be a sovereign nation. You have to be civilized. Māori people were not civilized, therefore they were not a sovereign nation, therefore they could not sign the treaty, and therefore they had no rights. So in 1901, after 24 years, the treaty was finally reinstated by the Privy Council. 24 years. So during the period of its nullity, Māori suffered huge losses in land and resources. It took 135 years to pass an act, the Treaty of Waitangi Act, 1975. This act, which could enforce the acceptance of obligations in a bicultural milieu, it was only in 1975 that Parliament could bring itself to address the principles of the Treaty of Waitangi and to provide Māori with a forum, namely the Waitangi Tribunal, for the airing of grievances against the Crown in terms of these principles. It was not until 1985 that we saw the Waitangi Tribunal Act amended to allow grievances to be considered from any point since 1840, rather than as previously from the date of the Parent Act of 1975. So in 1986, the Labor government passed the State-Owned Enterprises Act. And in response to Māori protests against the provisions of that act, in a hasty sort of late night decision, they inserted a new Section 9 to the Act, which required the Crown to act in accordance with the principles of the Treaty of Waitangi. So in 1987, this statute came before the Court of Appeal. A special full court of 5 judges, in considering the principles and relevance of the Treaty of Waitangi, unanimously confirmed the partnership established by the treaty. So following this, Chief Judge Jury issued the following statement, and I quote, "The Treaty of Waitangi is the founding document of our nation. Our modern independent state was not based on colonial conquest or the illegitimate invasion of settlers. New Zealand is founded on an agreement that continues today as a pact of partnership. Partnership between Māori and Pākehā. It is an agreement that established our continuing links with the Crown. It is an agreement which continues to act as a national symbol of unity and understanding between cultures. So that's our treaty partnership. We turn to Ahuriri. In 1916, my grandfather, Peter Hohepa, and others made application to the Native Land Court for Ahuriri over 100 years ago. In 1932, his brother, my granduncle, Ahuriri Hohepa, and others lodged a petition to Judge Harvey for Ahuriri. They waited 16 years until 1948 for the decision from Judge Harvey, which was immediately embargoed by the Crown. I mention these because they are whānau close to me, but not to discount the importance of so many others of our tīpuna who petitioned beginning as far back as 1902. Sorry, as far back as 1907. Mana Ahuriri Trust was established on the 23rd of September 2016. Established as a private trust and is the post-settlement governance entity ratified to receive and manage the Ahuriri settlement. It has a first past the post electoral system and structure. It is not a hapu representative structure. Trustees are responsible for all of the individual registered members, regardless of which eponymous ancestor that they as trustees whakapapatu. The governance board is made up of 9 trustees as per the trustees. The deed of settlement for Ahuriri was signed in November 2016. And I encourage you to refer to the Te Arokechi website to cite the deed and in particular the Crown's acknowledgement and apology and its recognition of the Crown's breaches of the Treaty of Waitangi and its principles in its relationship with Ahuriri Hapu as described in the historical account. Currently, we're working our way through the process of getting our bills through the House. The focus of Mana Ahuriri Trust to date has been to establish and maintain key stakeholder relationships. And we believe that the relationship we have with this council and others is very positive indeed and aligns well with the treaty partnership that we have post-settlement. I thought it was important today to talk about the establishment of that treaty partnership and how real it is for us, and the road that we had to take to get some recognition for the treaty. Thank you for the opportunity of delivering today, Rick. Kia koutou i oku rangatira, tēnā koutou, a tēnā tātou.